the courts must adopt such an interpretation which glorifies the democratic spirit of the Constitution. Your lordships has only one defense for us, apart from condonation, of merger. Merger is the supreme irony in this case. Merger is not even alleged by them, claimed by them, raised by them. In case of a merger, suppose 8 out of 10, 6 out of 10, 9 out of 10 leave, the remaining chap left behind is protected. Under your lordship's 10th schedule is protected. He otherwise he's a loner. He would himself be is protected. Here, but for lordship's interim order, which we argued just a few days ago, I'm not protected. Without claiming merger, today they are issuing letters and whips, which I'm not talking about lordship's protection. The whip is being issued as we speak, in various matters, they are entitled to, if the EC has recognized them. But for lordship's protection, I would be liable to be disqualified for not following his whip. Because without invoking merger, without getting a merger, there is no protection. They become the party. These are consequences. This is a consequence lordship I add in my 6 consequences. This is a very weird consequence. It's a very weird consequence. If you have the defense of a constitution, you are worse off. If you don't take the defense of the constitution, you are better off. I should have mentioned in the consequences list, lordship will consider putting it there. It's an absolutely absurd, weird consequence. Then, I have extracted para 4 in para 23, that is para 4 of the 10th schedule. And I made this point in para 24 again. And therefore, I have ended with this. I'm ending my submissions with one judgment which I have to cite. That's an absolute end. That's an interesting judgment on where is it found? Where is it found? EF. Compilation of judgments, volume 3F. It's a judgment called Indore Development Authority 2028 SCC 129. Constitution bench.
On restitution. On restitution.
Yes. Your lordship is a party to it.
Restitution, no?
Restitution. Because that's the 5th facet or 6th facet of setting right a wrong. You call it actus curiae, your lordship will not allow your lordship's acts or judgments to harm a party. Your lordship calls it a situation created by your lordship's order, etc. Another facet of saying the same thing is restitution. And my lord is absolutely right. My lords have got it. The principle of restitution is founded on the ideal of doing complete justice at the end of the litigation. I emphasize the word complete justice and I emphasize the word restitution. And parties have to be placed in the same position but for, I said but for test, but for the litigation and the interim order. These are very, very important words on the constitution bench. But for, that's the test. But for the litigation and interim order, if any, passed in the matter. In southeastern coalfields, it was held that no party could take advantage of litigation. It has to disgorge the advantage gained due to delay in case the list is lost. The interim order passed by the court merges into a final decision. The validity of an interim order passed in favor of a party stands reversed in the event of a final order going against the party successful at the interim stage. Section 144 of the CPC is not the fountain source of restitution. It is rather a statutory recognition of the rule of justice, equity and fair play. The court has inherent jurisdiction to order restitution so as to do complete justice. This is also on the principle that a wrongdoer should not be perpetuated, wrong order should not be perpetuated by keeping it alive and respecting it. In exercise of such power, the courts have applied the principle of restitution to myriad situations not falling within the terms of 144. What attracts applicability of restitution is not the act of the court being wrongful or mistake. So this is apart from actus curiae or an error committed by the court. The test is whether on account of an act of the party persuading the court to pass an order held at the end is not sustainable, resulting in one party gaining an advantage which it would not have otherwise earned, or the other party having suffered an impoverishment. It's very well put. I would commend each word of this. Litigation cannot be permitted to be a productive industry. That is only a fond hope. It is a productive industry. Litigation cannot be reduced to gaming, where there is an element of chance in every case. If the concept of restitution is excluded from application to interim orders, then the litigant would stand to gain by swallowing the benefits yielding out of the interim order. Then the quote, I will not read the quotation. Just pause here for 5 seconds, fellows. I get an interim order. The interim order is obviously not confirmed. If the interim order is confirmed, the matter doesn't arise. It is other way around. But every consequence of the interim order is enjoyed, gorged, eaten, and then you twiddle your thumbs and say, tough luck. Now the final order has come too late. You can't ask for restitution. That is what your lordship seek to address by this passage. It's rather well put. For saving of time, I'm not reading. I would request my lords to read Eastern Coalfields, from where it draws strength. It's a constitution bench. And Malas, this is the essence of justice. It's the essence of justice. In a constitutional matter with such grave consequences, it is even Malas A for sure. I'm very deeply obliged.
Just one question I had. I mean, it's a facts part. You said, and both Mr. Sibal also said the same thing, that this is not a case where a trust vote is called when the House is constituted for the first time. So that the governor's powers, of course, the governor has the power to call for a trust vote when there is no clear majority under the law.
It's not after the election that you have for the first
time. It's not after the election because here the government is formed. Very valid point that, this is post-formation of government. What is the power of the governor to call for a trust vote post-formation of the government? What are the circumstances in which he can...
That means a running government.
A running government.
Correct. Well, let me answer on first principle. That of course, we can add some material and give your lordships, specifically and not only on this. But on first principles, the first answer is that zero, where, because lordship will decide abstract. Zero, answer to lordship, direct question, direct answer. Zero power, where there are pending disqualification issues in a running government. Because lordship should not mix up the two. One is a normal vanilla running government with no issue of disqualification. One is a disqualification pending at 2 levels. My candid, clear answer to your lordship's direct question is zero. Number 2, the reason is what I have given Manas. It is a lateral entry of the executive in an area where there cannot be any jurisdiction. There is no locus for this in either 10th schedule or lordship jurisdiction. Number 3, if your lordship's question is premised, has to be premised and rightly premised on the assumption that the governor, what he does in the question posed by the Honorable Chief Justice, what is he doing, Malas? He is recognizing ABC as the inverted commas majority. There is no relevance to your lordship's query unless the governor does that. Otherwise, your lordship's query would not be relevant. Obviously, please suppose that he is giving some imparting legitimacy, recognition, or some status. How is that possible?
There's only one gray.
In constitutional law, it's not possible.
Not so much from the facts of this case, but we're looking at now from the law's perspective. On the facts,
I tell lordship,
that letter of the 28th of June 2022, the governor, you said that what the governor essentially did was to recognize a split by the letter. In fact, that letter does say that so many people have left you, and therefore, that
without using the word split is a full recognition of my submission to lordship.
De facto recognition of a split.
Yes.
Correct. Now, your answer to that is that the governor, so long as the disqualification petitions are pending, he cannot call for a trust vote for the simple reason that you are still a part then of the government which is supported when the House was formed.
Except in one case.
Right.
Where, for some freak reason which I cannot think of, it will never happen, that nobody decides to seek to disqualify the other. Now, suppose...
The speaker, what he may do is that I just disqualify you at all.
No, but that is not so simple.
Contribute to the majority of the...
No, but I am doing a juristic answer to your lordship's query. It can never arise in practice, but I am giving a juristic answer. That will have to be a situation where there is no cavil and dispute. I mean, it is virtually by consent of everybody. But with that answer comes a caveat. It goes back to the origin and the object of the 10th schedule. Why was it enacted? It was enacted not to encourage these trust vote situations by defections. Unless that is so, it will rise every week, every 2 weeks.
One of the last points, maybe we can take 2 minutes to put this to the other side also.
Yes.
So what is there's no clear answer.
No, I'm very grateful because it helps us to clarify in our own minds also. Which is to clarify now.
there is in assessing the strength of a ruling party in the House, whether it's the Legislative Assembly or the Parliament, you have a numerator and you have a denominator. The numerator represents the strength of the party when the House was formed. The denominator represents the total strength of the House. Now, by calling for a trust vote on 28th of June 2022, the governor, according to you, your argument is that the governor therefore recognizes that a part of the numerator has evaporated or has been taken away.
It's rather nice to put in numerator.
The numerator has been taken away. And therefore now I feel you have lost the confidence in the House. According to you, that is not permissible because the disqualification petitions are still pending.
And he recognizes and gives legitimacy to the numerator. In your lordship example, he is recognizing and giving legitimacy to the numerator.
The only problem which I think, which is kind of not, which is worrying is, does the governor not also recognize that the very act by which the numerator may or may not be affected? Alright? For instance, the numerator would be affected even if you don't treat it as a split and there's a clear disqualification. Then the numerator is reduced by X, the strength of the ruling party in the House, minus Y, the people who have defected from, who have therefore attained disqualification. But equally that same act affects the denominator also.
Because it reduces the total strength.
The total strength of the House.
Correct.
So, though the governor cannot therefore say, the governor cannot legitimately say that, look, these people have left you, therefore I want to trust.
Correct.
But can the governor not then say that, look, assuming that there is no recognizable concept of a split now under the 10th schedule, the effect of all this is that these people have to be reduced both from the numerator and
straight away. There are many answers. First, this exercise cannot be done by the governor because there is no mechanism for it generally.
You have been arguing that he can't assume to himself to take a decision.
First, you have lordship 3 or 4 answers. Lordship, note down my very specific answer. This is an exercise itself which he cannot embark upon. The governor has no such jurisdiction to embark upon when there is a running house. Now, second answer.
Right. He can't embark. But can you not, therefore, they then say, I want this exercise to be demonstrated on the floor?
No, I'm saying that exercise you can't embark. Let me answer.
Can you not?
He
has argued that.
Second answer.
Argued that he won't have the. It has to be.
Whereas numerator, denominator, you can't start because your lordship has to premise a direction by me to him. I'm the governor, I'm giving him a direction.
In other words,
please have the argument. You can't give a direction.
Got your point. Therefore,
the legislature, the speaker or the chief minister can say, sorry, I don't know where this direction. I don't hear this.
Finish your argument, therefore. Yes. Until the outcome of the disqualification petitions is known to the governor,
exactly,
he cannot then call for a
trust.
Possibly, using your line of argument, we're just trying to understand
yes,
and stretch it to its conclusion. After the disqualification petitions are decided by the speaker, then there is clarity in the mind of the governor on what is the extent of the numerator which has been affected.
I'm very grateful. I was going to answer, I'm not conceding, but I was going to answer because that question doesn't arise. Lordship will be very careful about a hypothetical situation, but possibly, but because why is that? Because a constitutional designated judicial or quasi-judicial tribunal has given a verdict. After that, there is something, as the Lordship puts it, that verdict, unless disturbed by the High Court or Supreme Court, is binding or operative. But here, because your Lordship's query answers the first part, you are doing it well before.
You say another point in your favor, actually, which is that the very same unit which affects the numerator affects the denominator also.
Yes,
right. So, if the governor cannot postulate until the disqualification petitions have ended that the numerator has been affected, then he cannot say that the denominator is affected.
No, he cannot. By the very arithmetic, it has to be both. It is very selective otherwise.
Right. Because the same act of defection which reduces the strength of the ruling party, which also then affects the strength of the House.
And Manas, can you start doing this in a this is the word premature stares your Lordship in the face. Constitution says this body will decide. This body is elected to decide. You go and give a decision virtually. I will reduce the denominator, I will reduce the numerator. That will create chaos. And Malas, Your Lordship has to see, it's the
You are saying
also the
he can't take cognizance of the existence of the 10th schedule proceedings. He can take only upon an
After
order passed by,
consequence of the 10th schedule
or
proceeding.
after a determination by the 10th.
That's a very pithy summary. The consequence of the 10th schedule can be some basis, unless disturbed by the High Court or Supreme Court, to act.
Until then, they continue to be members of the.
And it would be in rem. Once that,
Otherwise, this would be really a method.
there'll be chaos. There'll be chaos. And unless, not that it should come into your Lordship cannot ignore the reality of around the country. Governors also. Governors are no more angels.
Just 2 cents. Number one, 10th schedule doesn't recognize majority minority.
Absolutely.
Correct? 10th schedule postulates, that even if there is a split of a majority, it can't be recognized. The governor knows that. The governor knows that, And 10th schedule, also, para 3 also said there must be a split in the original political party. 10th schedule, para 3 said original political party. Right. We know that there was no split. Governor knows there was no split in the original political party. So on what basis will he ever recognize? And your answer to your Lordship's question, how will the governor call, supposing one of the parties moves away from the coalition and goes to the governor, along with the BJP, and said, now we are...
That's not an individual act of defection.
Yes, that's right. So this is an individual act. It has to be the act of a party. Now you have recognized the majority as the party and writing a letter to the Chief Minister. This is unheard of.
So if a party says we don't support the government anymore, that's not a disqualification.
That's
we don't support. If the governor says you've lost one of your constituents,
Government falls.
That's fine. That's all right. So I'm sorry, but I didn't want to.
Very deeply obliged.
Thank you, Dr.